The state says former President Jacob Zuma relies on conjecture and conspiracy and not credible evidence in his special plea to have advocate Billy Downer removed from the so-called arms deal trial. In his submission, lead counsel for the state advocate Vim Trangrove has told the High Court in Pietermaritzburg that the defense wants to hold an inquiry into issues that have already been ruled on by the Supreme Court of Appeal in 2017. The state and the defense are making their submissions on the second day of the special plea hearing. Yesterday, Judge Piet Koen allowed the plea application to continue without Zuma being present. He put the issue of Zuma's fitness to stand trial aside for now. The former president is facing corruption charges. For more, we cross to our reporter Ayanda Mhlongo, who has been following the court proceedings. Good afternoon, Ayanda. On those proceedings, we heard those arguments being brought forward by Advocate Dali Mpofu. Perhaps you can take us through his submissions.
Yeah, very good afternoon. Well, let me first start here to say that, of course, the judgment has been reserved and the matter has been postponed now for the 26th of October, where Judge Piet Koen will then deliver his judgment after a day and a half of arguments between the state and the defense. Of course, today, the defense advocate Dali Mpofu, on behalf of former President Jacob Zuma, wrapping up his arguments or rather replying to the submissions that had been made by the state. But just more on this and just to unpack the arguments that were put forward in their rebuttal, I'm joined by our legal expert, Mr. Mpumelelo Zigalala. Mr. Zigalala, thanks again for staying with us. Just to get your thoughts on the 5 points that were made by Advocate Mpofu as he replied to the state submissions.
They're definitely sort of repeating what he had said yesterday, of saying that please apply your jurisdictional powers as the court. Make sure that you extend and apply a wider interpretation of the no title to prosecute. We know that ordinarily it's usually in the administrative realm, but now we want you to take into the conduct of the prosecutor in this case to further extend it. And what was sort of not surprising, but a strategic move on their side was to say, our first prize is that the title to prosecute must be removed, the matter is struck off the roll, or a declaratory order, as you called it, that you cannot prosecute anymore. Alternatively, if you feel that you still need to hear evidence in this matter, allow us to bring in viva voce evidence through the witnesses which we are going to call before we get into the merits of the matter. Now let's look at the potential list of those witnesses. I think Advocate Mshe may come in, Advocate Vuspikol may come in, and others that were within the higher echelons of the NPA at the time, to come in and explain the nature and the conduct of the NPA, why it was doing this type of investigations. So that was a bit, I wouldn't say surprising, but it was adding on to their quest of saying, we indeed believe that the conduct engaged by the NPA does not allow a fair trial in terms of Section 35 of the Constitution.
Advocate, and you've spoken about what Advocate Dali Mpofu was saying, linking the, should the judge rule in their favor, that they would then want an automatic acquittal. Is it that simple though? Not
necessarily. Let's remember, our criminal law, applying the Criminal Procedure Act, but mostly underpinned by our Constitution, then says, even if the methods in which we have drawn you here into this arena, there's a case that you must answer to. We are going to allow the state to put in the case through, and you must answer to it if you feel that there are certain things in which you must answer to based on those allegations. You have Section 174 as a safe net that says, after that case has led its case, you then come in and say, but the elements of the crime I'm being accused of has not been achieved. You must dismiss me based on the acquittal. There are other rules of evidence that says what type of evidence can be brought in or excluded here. And even when it comes to appeal, it's another opportunity for you to plead your innocence. Now, to then say, I want to be free on this particular technicality, it's something that the court will not do willy-nilly. It's something that the court will then say, there are instances in which in the Criminal Procedure Act that allow you to deal with those type of proceedings. Let's not do it now. Allow the state to come in, bring in its case, and then we'll take it from there.
Earlier on, we were just speaking about the timing, and this was debated between the two sides. The timing of this application. Do you feel that it was the correct time for the defense to lodge this special plea with the court?
Based on, let's separate it into this instance. The intention or the real application, if you look into the conduct of the prosecutor, then that should have been brought in at a later stage, because you must allow evidence to be led by saying, when witness one goes into the witness box, then you say, let me look at the conduct of the prosecutor in this case, and vis-a-vis how my rights in terms of section 35 are then infringed. Another option that may be there, if this one fails, by the way, is to say, I want to make an application so that I'm able to access Part C of the docket. Just remember, Part C is not readily given to the defense. You have to make a special application for it, because that's where the communication between the investigating officer and the prosecution lies. And based on the type of entries that are written there, you then be able to make inferences of saying, ordinarily a prosecutor wouldn't ask for this type of information if there's no element of bias attached to this matter. They are purely doing it due to their work as a prosecutor, and their sole interest is that justice must be served. Now, if we don't have access to that Part C, it makes it very difficult for you to prove the impartiality, the non-compliance with the NPA Act in which is being alleged by the defense in this case. So that's another avenue that is there. But on a technical and a strategy basis, maybe if the strategy was to first get what does the NPA have in its bag, I think it would have been better if this application was brought in at a later stage.
All right, moving forward now, it now lies with Judge Pitkun to decide whether or not he will rule in favor of the defense or the state. Should he rule against the applicants in this matter, do they have any further recourse?
They do. You still have the Supreme Court of Appeals. In fact, you can still go into this division with the full bench. After that, you go to the Supreme Court of Appeals. Even if you fail in that court, then you can even go to the Court. So there's a long way that they could still travel if they solely believe that this matter must be traversed, and the only court that will give them reprieve is the highest court in the land.
Still a long way indeed. Mr. Mpumelelo Zikalala, thank you so much for your time in unpacking what happened in court for us. Still a long way to go, of course. That will depend on Judge Pitkun and whether or not come October the 26th he rules in favor of the defense, Mr. Former President Jacob Zuma, or he rules in favor of or he would then agree with the state, which have asked for this matter to be dismissed, Natasha. So we'll have to wait until October the 26th when the judge is ready with his ruling. Of course, he did mention that it is going to be a holding date. He might not necessarily be ready on that date, but he did indicate that he was going to at least try to ensure that his judgment is ready on that date. But the holding date for now is October 26th. Natasha, back to you.
Ayanda, thank you so much. That is Ayanda Mhlongo live outside the Pietermaritzburg High Court.